Ms. Hanabusa.
Thank you, Mr. Chair. Mr. Engel, there's a statement in your testimony that I think kind of gets to the essence of all of this. You said the traditional law of wars are premised upon a conventional international armed conflict, or in some cases civil wars. The established legal framework provides clear answers to who may be detained, how they must be treated, and where they should be prosecuted. None of these questions is self-evident when it comes to the war on terror. So can you tell me why it's so clear in the other situation and why it is so muddy in the situation of the war on terror?
Sure. Well, I mean, largely when you're talking about the conventional laws of war, you're talking about the Geneva Conventions, you know, by and large, and the common law that has been worked out around that. And the Geneva Conventions really do provide specific answers to how we treat prisoners of war, you know, those legitimate combatants who meet these standards. And it talks about where they can be kept. It talks about where they may be prosecuted if they are to be prosecuted for war crimes and the like. And none of these questions really exist or apply when we're talking about individuals who are not prisoners of war and individuals who are not covered by international armed conflict. We've seen some clarity, particularly with the Supreme Court's Hamdan decision and the way in which it interpreted Common Article 3, that has provided some baseline treatment standards and the like. But many of these other issues are issues that have been worked out by the executive branch with Congress, with the courts, and the answers even now, almost 10 years later, you know, are not perfectly clear.
So if this war on terror, or however variant that we may continue to call it, if we're going to continue in this murky area?
Well, look, I think we have more clarity now about these standards, a lot more clarity now than we had you know, on 9/11. I think the United States has taken the lead. I think Congress has taken the lead in elucidating, you know, the governing law. Because when we talk about international law, when we talk about the laws of war, apart from things like the Geneva Conventions, these answers don't exist in the sky. The written bodies of law, there is no criminal code or for the law of war as such, but it is worked out from time to time. And I think we do have some answers, but as we've seen, you know, from this discussion, and we've seen from the reaction to Section 1034, there are still questions that are being worked out.
But it's a unilateral act versus something that you would see that nations would get together and sort of agree to some kind of basic premise, and that's what I see as the problem. I'd like to speak to Mr. Is it Mukasey? Is that correct?
Yes, it is. Thank you.
Okay. And this is regarding the, I know I'm going to not pronounce it correctly. Is it the Boumediene decision? And I think you were Attorney General when that came out in 2008. Okay. One of the things that I found in the decision that struck me and wanted to discuss with you is the fact that towards the end, the Supreme Court says that because conflicts have been limited in duration, we've had the ability to have the outer boundaries of war powers undefined, basically the presidential right, and I think the discussion was a separation of the powers. What I'm curious about in reading part of the testimony that we've had is, given that situation and given the thing that the Boumediene decision seemed to have also looked at the geographic area of what is the status of Guantanamo, for example, and they talked about the insular cases. I'm from Hawaii, so of course the insular cases development is very critical to me. So what I'd like to know is, at what point are we going to see this clarity? Because at some point we, as Congress, cannot legislate to the point where the Constitution and the Supreme Court comes back and says, well, you can kind of do it for now, but at some point we're going to address this issue, and I'd like to know how you thought about that.
Well, I think that you have to legislate in the here and now, and you have to legislate with what we have. So far as past conflicts being of limited duration, I should point out that that is only in retrospect. The Germans didn't march into Poland in 1939, scattering little pieces of paper saying, don't worry, this is all going to be over by 1945 and the Fuhrer is going to blow his brains out. That's something that we achieved, and it was limited in duration only in retrospect. This conflict, I'm hoping, will have an end. How are we going to know? We'll know. And it's not something for us to worry about while it's ongoing. What we have to worry about while it's ongoing is how we behave and how we treat our adversaries. And the fact that this committee is holding hearings like this and passing the kind of law that it has passed on to the House and that passed the House, is wonderful testimony that we are a nation that does that and that worries about those things. But I don't think we can sit here and worry about the duration of the conflict and paralyze ourselves from acting. We act with the facts as we know them. If the facts change, you can always change a statute. But inaction is going to get us in a place that we don't want to be.
Thank you. Thank you, Mr. Chair. My time has expired.